Hello, everyone. I'm Kevin Gostola, managing editor for Shadowproof, also the curator for the Dissenter newsletter. And thanks for joining me for this report on day two of the US government's appeal. And we wrapped it all up. The High Court said thank you to both of the sides, to the defense attorneys, as well as the US government. The Crown prosecutors who are representing the US government said that they were going to take everything into consideration. We have no immediate decision. I suppose that's the most important thing to be clear about right now. We do not know what the High Court's decision will be on this case. And nor do I really want to speculate on their attitude toward the case. I'm not sure that they showed their hand. You could read into some questions that were asked of the defense. Certainly, a fact that can be stated is it seemed the High Court asked more questions of Edward Fitzgerald and Mark Summers, the two attorneys for Assange, who were making statements on the second day. But I don't know if that is an proof that the High Court is going to rule against Julian Assange. So it's right. It's right to be cynical. There have been countless times along the way that has been proven correct to be cynical. But then again, I remind you that when I listened to the decision coming from the district court judge, Vanessa Baretzer, I was certain that they were about to sign Julian Assange's extradition request and pass it along to the foreign secretary, and that then he was going to be on his way to the United States, aside from the fact that the legal team for him would would immediately appeal the entirety of the judge's decision. So that was shocking. That was something that I was not prepared. I was not prepared for the judge to recognize that it would be oppressive for mental health reasons to send him to the United States to be put in a prison, whether it was jail while he was in pretrial confinement, or whether it's a prison, could be a supermax prison. It could be any number of facilities, which we discussed today. So just to run everything down at the top, I'll begin by saying that the easiest way for you to get a lot of the details on what went down today is to go to the dissenter.org, where there will be a report posted later. I'm collaborating with Mohammed Al-Mazi, who is in London. He's been able to attend proceedings. And so we're going to work together on covering what happened with the defense today. Today, the defense was able to respond to all of the arguments put forward about the grounds for appeal. And just to be clear, I've got these all handy here for you. So let's just run through the grounds that we have that were put forward by the United States government, and that were then responded to by the defense today. So you have this first ground, that the judge improperly applied UK's extradition law. And there's a test called the Turner test, which received some attention by Fitzgerald during today's proceedings. Ground two is that the judge should have let the US offer assurances if she was going to deny the request. And it's the position of the US government that they could issue these quote unquote diplomatic assurances at any time related to how Assange would be treated within their custody. Now we go to ground three, which is the judge ought to have disqualified a key psychiatric expert. This involves a psychiatrist who was assessing Julian Assange on a pretty regular basis from May 2019 to December 2019, after he was expelled from the Ecuador embassy, after he was arrested. And he was also doing time on a quote unquote bail jumping charge that the British government left hanging over Julian Assange so they could have a pretext for arresting him. And this was something that Fitzgerald spent a lot of time on in the morning. We'll come back to it. Ground four is that the judge erred when considering evidence of suicide risk. A lot of this turns on whether and this is because of law. This isn't my way of thinking about this matter, but it's because of the way the law in certain past cases have been decided, that they have to show that Julian Assange would not voluntarily make the choice to commit suicide, that in fact it would be a result of impulses from a mental health disorder. And so, because doctors assessed this and made the determination that being put in any type of isolation or harsh restrictive conditions, losing his family support network, for example, because he would be in the United States, and most of the people who have supported him while he's been in Belmarsh High Security Prison have been there since they're in London, that this would contribute and lead to eventual act of him taking his own life. And so this is something that was raised quite a bit in the morning by Edward Fitzgerald. Ground five is that the UK government was offered a package of assurances to address the judge's decision. And we know what these assurances are. Those assurances are basically that they're saying, we no longer intend to put Julian Assange in ADX Florence, which is the supermax prison. We no longer would put him or designate him for special administrative measures. We would allow Australia to have custody of him. We would agree to a prisoner transfer if he is convicted of these charges under the Espionage Act that Julian Assange faces. And also, we will make sure that there's a doctor. They say we'll have a doctor recommend that he receives the medical care that he needs pursuant to his mental health conditions, something like that. And so all of this, these are the assurances that we see being put forward in order to make an effort to salvage this case, because they did not do this before the judge ruled against their decision. So they're trying to revive this case by impressing upon the High Court that no, we are going to take the utmost care with Julian Assange. And I think that's a good way to begin and get into all of this. And I'll work backwards and just say that we saw that Mark Summers pursued the issue of whether you can trust the United States government, whether you can take seriously that the U.S. government is acting in good faith to put forward these assurances. And we were able to hear Mark Summers discuss the Yahoo News report that was put out by Michael Isikoff, Zach Dorfman, and Sean Naylor, where they dug into the sketched out plans that were made by agents within the CIA with encouragement from CIA Director Mike Pompeo, who had declared that WikiLeaks was a non-state hostile intelligence agency, that all of this is happening within the US government. And now they are going to pursue a legal case, and it's supposed to be fair somehow. It's supposed to be unbiased to the accused in allowing due process to grind its gears. However, when it comes to SAMS, the CIA gets to make a recommendation to the Attorney General that Julian Assange could be placed in special administrative measures. And the assurances leave it open that something in the future could happen where Julian Assange was designated for these conditions, even though they say, oh, well, we recognize that the judge had an issue with him being put in SAMS due to his mental health. He would not be able to handle being put in SAMS. And they make the point that, maybe they would be afraid that some breach of national security could be coming, that they could still view Julian Assange as a continuing national security threat. And that's why he would be put in SAMS. That's exactly why they have this system of SAMS. that more like most of the time this is imposed on people who are terrorism suspects, and after, if they're convicted of terrorist offenses, then that's what they would do to handle it. But the source of the Vault 7 materials, Joshua Schulte, sorry, let me backtrack. I got to be very accurate with this. The alleged source of the Vault 7 materials is confined right now under SAMS, and that's even after a mistrial. And that's how they're treating him. And he's the source who doesn't even have the kind of high profile that he's the alleged source who does not have the kind of media attention that Julian Assange has. And so you can just imagine the way in which they're going to treat Assange. And they've even hinted at some of the way in which they may have to have protective custody for Assange because he's well known. And so you can see how some of what they might like to do to isolate Assange will be wrapped up under the guise of safety, that they're just taking care of him to make sure he's able to get to trial without anybody threatening him who he might be confined with, whoever that might be. So I have a guest. I have somebody who has agreed to join me in order to continue this. And we're going to keep up this broadcast for another, 20 or so minutes at least. And then I'll wrap this all up. And so let me bring in, it's Chip.
Hey everyone, Chip. How's it going?
We're seeing you live.
Here we are.
What do you think? You've been following the proceedings both days?
I have. I think you made a good point about the protective custody, because I want to point out that as a matter of policy in the past, the Alexandria Detention Center, where Julian Assange will almost certainly be held, has a policy of putting high-profile detainees in administrative segregation. They did this to Chelsea Manning. They did this to Paul Manafort. I know very early on in the Paul Manafort legal proceedings, he was in a very cush jail that people thought was too nice, because we have liberals who think prison is too nice sometimes. But he was later moved to the Alexandria Detention Center and was in the same sort of draconian conditions. And Marina Butina, the accused Russian foreign agent, was also there and held in administrative segregation. So we pretty much know what it would look like if Julian Assange was to be held at the Alexandria Detention Center. And, when Chelsea Manning was held there, Defending Rights to Dissent was very active in campaigning against her conditions. We sent a confidential note. Obviously, I can talk about this now, but I couldn't at the time, to the UN Special Rapporteur on Torture. We wrote to the sheriff, because the sheriff controls the local jail. So it's really not much of a question what Assange's best case, and we're talking best case, terms of confinement will look like, and they meet the international standards for cruel, inhuman, and degrading treatment. And I was just sort of livid just watching this British prosecutor say it's not solitary confinement because he can be with his legal team. Like, I've never in my life heard that argument, and I used to work on.
Chip, I mean, don't you know, if you can meet at any time with your lawyers and just continue to have chat sessions with them, like they're your friends or family, because that's what lawyers have the time to do, right? Like, they're just there as like your social other that you can, I mean, these are professionals. They have like work to do. They can't just come in and like hang out with Julian Assange. Anyways, continue.
Yeah, no. Yeah. And it's a ridiculous claim. It is a fundamentally ridiculous claim that they made. And I was really shocked by it. And like, I used to do some like work around solitary confinement in Maryland circa like 2013, 2014. And, one of the things we were always warned about was that people will use terms like administrative segregation. There's a list of other ones, reflection cottage in juvenile facilities, to sort of avoid taking responsibility for solitary confinement and say, no, we don't have solitary, you're in administrative segregation. And like, back then everyone knew that was bullshit. And here we are watching the Queen's or Her Majesty's prosecution, or whatever monarchical title they have, getting up on a world stage and making those same arguments. And it was appalling. It was appalling to watch.
Mm-hmm. So I had a little bit of an audio issue. I corrected it. actually sound a lot better at this point.
Excellent.
So I said a little bit about, so the CIA article was brought up. They were addressing some of this. I'll work my way back to the morning. The morning was all about psychiatric evidence. I do think that one of the more repugnant aspects, and obviously there are tons here, because, the thing, James Lewis said towards the end of the proceedings the words, in the interest of justice. And I was just like, nothing about this is in the interest of justice. The spirit of it is all about revenge. The spirit is that you did this and we are going to bring you to this country and put you through our legal system and deal with you in this manner that, we're going to create this veneer of due process. We're going to make it seem like we're handling you the way that we handle every other defendant that comes through our courts. But there are things that are obviously extraordinary, as Summers pointed to at the end there. I mean, I think it's good that he ended on this point, which was that this is the U.S. government asking the UK court to allow the U.S. to exercise jurisdiction over Julian Assange after an agency within the government plotted to poison, or worse, kill, or even below that, kidnap and abduct him and bring him back to the United States. And I don't know. I will say the one criticism I have is I don't think the High Court was really dealing with the gravity of what that means for them. The responsibility that they have to get this right, because a requesting state has done this to a defendant, or the person who is the subject of the extradition request.
Yeah, and I think the defense is, at a bit of an uphill battle with that one, right? They have the Yahoo article, and I'm not as familiar with the British legal system as I'm with the American one, but right, just in terms of rules of evidence, they would never accept like an article as like in a U.S. court as like definitive something and be considered hearsay. You'd have to have like direct proof from the CIA, and of course, the CIA is not going to turn that proof over to the UK High Court. And I'm really just sort of concerned, like you are, that the High Court is not taking the threat against Julian Assange's life seriously enough. They're not taking the UC Global stuff seriously enough. I mean, that they did hear witnesses, they did hear evidence of, and I think that's pretty affirmative. But I'm just curious. I'm just afraid they're going to like blow this off as like, oh, people out in the media have said things that no one knows, as though it's the National Enquirer and not, a very prestigious journalist who was there today, virtually speaking.
Yeah.
So I do think that, some of the frustrations with hearings like this, and this is often the case true with the US as well, is that you have these really sorts of important cases. This is a case about Julian Assange's life. This is a case about the future of press freedom. This is a case about the right to expose US crimes. And, they end up in these sorts of very convoluted arguments about, did they apply the factors of the Turner test correctly? And it's like, I mean, I understand this is a legal proceeding and it turns on these sort of complex legal issues, but when you have sort of the background of these shocking revelations about the CIA, confirmed by 30 former U.S. national security officials, and we're like talking about like which extradition test did we apply, and did we apply the 5 factors correctly? It feels so surreal. It's just so divorced from anything that's actually happened. And I know this is how law works. That's why I don't practice law.
Yeah. So I was going to ask you if you wanted to say anything about what I find to be one of the more grotesque parts of this, which is that they get to attack Michael Kopelman, this distinguished neuropsychiatrist, in the way that they have. And in fact, they mentioned that he has been used by the Crown Prosecution Service before when it came to past cases. And so it's not like he's a hack. It's not like he's somebody who has been dragged before some advisory board and warned that he needs to follow the rules as a psychologist or a psychiatrist. But he did something and decided that it wasn't good to disclose Stella Morris's relationship with Julian Assange and the fact that they had 2 children. And that was owed to a lot of the circumstances relating to her privacy and the UC Global, the Spanish security firm. So, I mean, but that's the background. That's what this is really all about. But anything you heard in the court, the way that this has been handled, your response?
It's disgusting. I mean, the whole thing is sadistic. I mean, just driving Michael Kopelman, who is a distinguished professor of neuropsychiatry, through the mud. They brought up this sort of interview he did that was in a British law journal where he said, "I like to work within the system to achieve justice," or something like that. And it's like, oh, the horror. You're working within the legal system for justice. Well,
Yeah.
you're not impartial at all. And just all of the attacks on his credibility, and just watching these like lawyers try to like second guess the judgment. I mean, yesterday they were like, "Oh, this eminent professor of neuropsychiatry found Julian Assange was depressed," but a lawyer, I'm saying, how could he be depressed because he watches racing on the TV in the and I'm not an expert, but I'm aware of no preclusion to being diagnosed with depression because you watch racing on television. I think it's bizarre, right? It's like, oh, they say he's suicidal, but would a suicidal person watch television in the afternoon? It's like, probably, yeah. I mean, I don't think that's in like the DSM criteria, like, does not watch racing, does not play pool. And it was just sickening. And the whole thing, the whole attacks on trying to undermine. I mean, people saw yesterday Julian Assange on camera. People who knew him in person and have known him for a long time have commented on how sick he looks, how frail he looks, how thin he's gotten. And to just sit there sadistically and pick apart, these eminent medical professionals' findings about him, or they ridiculed someone else who was brought in from the U.S. who was an expert, really ridiculed, who was brought in the expert from the U.S. as an expert in, I believe, PTSD. Oh, she's just a general practitioner who's friends with Julian Assange. And it's like, who are you to say this? I mean, you have no medical background. I mean, and you're just trying to pick holes in someone who's clearly sick, right? Clearly, everybody who has met him and has seen what he looks like now is extraordinarily disturbed. And it's a sadistic appeal. There's just no other words to describe it than this pure sadism.
Yeah, and the stigmatization of people with mental health or even mental health disorders. You say problems or disorders, however you want to put it, but I'm talking about diagnoses that come from people who are trained doctors.
Yeah.
And the fact that things like, this is a real thing that Fitzgerald had to say before the High Court today. People who have autism spectrum disorder have had girlfriends too.
It's
like,
really shocking.
It's have had partners, can have loving relationships with people.
Yeah, no, it is completely disgusting, right? I mean, many people with autism, right, have partners, have relationships. I mean, it's really very bizarre. The depiction of mental illness painted by the prosecution is just like, oh, it's really, it's gross.
And so one other thing to work in here before we start winding down is the issue of Australia. I think that's worth bringing up because it's not gotten a lot of play, but I think the newness of it is why we saw yesterday. For the record, I don't spend a lot of time reviewing the media's coverage of this case for the fact that I am a journalist who's doing his own coverage of this case. So I just don't really, I'd rather put forward what I'm writing and tell people, like, this is what went down today. I don't need to spend time reading somebody else's report and figure out how they didn't do it correctly. It's also a little awkward because, like, in real time, it's kind of like judging a journalistic colleague's work and like being like, oh, I did it better, you didn't do it right. But
you probably did do it better depending on the journalist, though.
But I know. What I'm saying is like there are usually only a handful of people. Let's be clear. There were like 70 people, maybe 50 of them journalists who are doing coverage. A lot of them are coming from court. Several of them are coming from court news services. Others are coming from wire services. Some of them are international journalists.
A lot of French media.
You've got people writing in foreign languages. So those who are only English speakers, primarily like myself, we're never going to see what they've done, unfortunately. And it's probably good work. But that's just to say that I noticed yesterday that the big thing was Australia and the assurance that would be that Julian Assange could do his prison sentence in Australia if he wanted. And I'd like to just take a moment, and you can add to whatever you'd like after I go through this, Chip, but I want to like make sure everyone who is tuned into this broadcast knows what the defense's points were on this. You know, again, I'm doing this because I spent a lot of time talking about special administrative measures, and I'll be doing that until I'm blue in the face and this case has finally been dropped or has died. And I've talked about the issue of going to the Supermax prison. We've started to get into communications management units finally, especially since drone whistleblower Daniel Hale is in one. And it seems like a real possibility that Assange could end up in a CMU if he were convicted in the US. But now we have this thing of, well, we might be able to get around our prison issues by just sending him to Australia. Now, what the defense says, and I'm just going to read from their submission, the prisoner transfer assurance is meaningless. On the evidence, Assange will most likely be dead before it could have any purchase, if it ever could. It amounts to no more than a promise of prosecutorial consent to the application. It assures nothing about the ultimate decision on approval of transfer to be made by the Department of Justice at their complete and unfettered discretion. The subtle but deliberate and crucial distinction was discovered to their extreme cost by the Spanish authorities in Mendoza. I'm not familiar with the case, but I'll read what they put here. The Spanish court made Mendoza's extradition conditional on prisoner transfer back to Spain to serve any sentence. In response, the U.S. provided the same assurance offered here to the Spanish court. Upon surrender, the prosecution did, as promised, consent to the application. It was then, however, refused by the DOJ when the Spanish court complained of the clear breach of the assurance. The USA retorted that, quote, the USA did not make and therefore could not and did not renege on a promise guaranteeing that Mendoza would comply with the sentence imposed in Spain. And then they continued. The promise that was made at the time is that Mendoza could apply to the protection treaty of the Council of Europe to serve any sentence imposed on him in Spain, and that he may apply again. So far as the U.S. is concerned, the fine wording of the assurance is what matters, not what the extraditing court thinks it means or wants to achieve. In short, the devil is in the detail. And then they go on. And they also point out that as far as Australia goes, they may not consent to it because it would be a political decision made by the government, whoever was in power, and that it would mean that political decision makers have to concur, and anyone could decline and say that they don't want Assange to come to the country. They'd have to permit the transfer if also they decide that he's been sentenced to prison with a disproportionate sentence, then they may not want to be party to this political case. So those are important things to lay out related to this whole deal of Australia just suddenly makes it all okay.
Yeah, it's. I would not really trust any of the U.S.'s assurances with Assange. I mean, I think that the suggestion that he would be dead by the time this ever got anywhere is unfortunately probably very probable, given where this is going. So I'm not taking with the Australian assurance. It's interesting to me the U.S. is even willing to entertain this question, which just shows you how desperate they are to get their hands on Assange, which makes me sort of even more suspicious of what they're up to. I mean, the U.S. has devoted tremendous resources uh, multiple U.S. attorneys' offices, the NSA, the CIA, the FBI, for just this decade-long war on Assange. It's a real vendetta, and I don't think they're just going to give him up once they have him.
All right. So, anybody, if there's anything you want to drop here quickly as we conclude here for like a question or a comment, anything you wanted to get to us for us to address before we wrap. But the big thing here is there's a panel at
3:00
p.m. You want to plug it, Chip?
Yeah, so there's going to be a panel at 3 p.m. Eastern time with Kevin and myself, and also Stefania, who is an Italian journalist who has covered the Assange case for years. She worked with WikiLeaks, some other revelations, and she's filed FOIA lawsuits against, I think, Sweden, the UK, and the US. I didn't even know Sweden had a FOIA law, so that's very, very exciting. I'd love to know what she's found, and it's going to be moderated by Ryan Grimm of The Intercept. So
yeah. Really good. And Ryan will bring the people who watch him on Rising and follow his Intercept work. And he just had Gabriel Shipton. He just had Gabriel Shipton on Rising, who is Julian Assange's brother. So, and he was actually gracious enough to have me on Rising a few weeks ago to talk about the Yahoo News reporting on the CIA's plotting against Assange. So this should be a really good discussion. And I'll also add that we were hoping to include Rebecca Vincent of Reporters Without Borders. I just want to take a moment to acknowledge that this press freedom group, has done some of the most tireless advocacy for Assange, has been doing, not only on Assange do they do amazing work, but campaigners like Rebecca do this incredible campaigning for all kinds of people throughout the world who are under assault from countries like the U.S. A lot of them are Western powers, but she does do a fair bit of work in authoritarian Eastern European countries. I've seen her. I'm not really familiar with those cases, but she's put up with a lot in trying to get access to the proceedings throughout this extradition case, and it wears on you. It's exhausting. She's asked to be treated she wanted to be in the courtroom and not just be on the video feed. And I think she had to work to obtain access, or she was in just the public gallery today. I'm a little unclear on where that all ended up. I think she might have just been in there like the public, because today
she got in because she was on the families list.
Oh, okay. All right. So
she queued up yesterday and waited in line. And then once they got into sort of, I guess, the lobby area, they did not respect the queue. And a member of the public who was unmasked became very belligerent, yelling at her. And then she only got in because the family put her on their list. And then today she did not bother waiting in the queue. She just went in with the family.
Okay.
This is what I read on her Twitter account. I don't know why I'm talking authoritatively, but that is what she just tweeted.
Sorry, I'm just a little distracted by the people who feel the need to tell me why I shouldn't participate in a panel moderated by Ryan Grimm.
They tweeted me a lot too.
It's neither here nor there what he said on other issues. He's pretty solid on Assange, and if you feel the need to critique him and apply litmus tests, I think that we're going to butt heads. So I would suggest that you go find another video feed to follow. But in any case, Rebecca, I know, was in the public gallery and had her phone, and she was trying to tweet and cover the proceedings today when we heard the High Court Justice sit there and say, I think it was the Chief Justice, was like, "You're being distracting in the gallery and we're going to need you all to put your phones away." Yeah. And so then she wasn't able to do the coverage that she was doing from her seat as somebody who was allowed to be there with the family. So that's unfortunate. I think people lost a lot. It would have been good to hear her insights in real time as she was following the afternoon's proceedings.
Yeah, her coverage has been great, and her treatment by the UK court system has been appalling.
Mm-hmm. All right. So it was good to hear from all of you. you're welcome to leave, Chip, and go recharge your batteries. I'm going to do a little bit of signing off for my subscribers and followers. But I'll catch up with you in a few hours.
And I will keep dragging you into panels with Ryan Grimm.
Yeah,
to the dismay of your, All right, have a good one, Ryan.
Ryan is so sleepy. So if he's so sleepy, then we're gonna be in good company because we're
that
just
what
exhausted.
Someone said he's sleepy?
Yeah, he's sleepy.
Well, I've been up since 4 and I went to bed at 1, so I don't know how I could be sleepy.
Yeah, I mean, so if you like lethargy, tune into this panel at 3 o'clock.
I think my eyes are bloodshot looking in the camera right now. Right, and I look like a crazy person. This is gonna be great.
Yeah, if you like people who look like they're near, like they're walking zombies, then this is going to be the panel for you. I don't know how Stefania's going to be doing. It's going to be late in the evening for her because she's in Italy.
Yeah.
So I hope she's able. So anyways, I'll see you in a little bit.
I'll see you with our sleepy friends. Goodbye.
All right, everyone. And I don't have much more to add to that, but let me just put a button on all of this. First off, to thank you for tuning in to my updates on both days. The support that people show my work it means a lot to me. I can tell a lot of people find me to be credible and they appreciate what I'm doing. And it's early mornings. It's getting up at 3:30, 3:45 in the morning in the United States to be up and to work. And then I'm exhausted. And by noon comes the time when everyone's awake in the US. And then it's time for me to do interviews and to do the drafting of the report that I'm going to put out for people who are subscribers of the Dissenter newsletter. And I do all of that because I think it's really crucial for us to challenge what is happening. And I know that Attorney General Merrick Garland has been going before Senate committees this week and testifying. And so far, you haven't seen any headlines about him being questioned on the matter of the prosecution against Julian Assange. There's been no one that I know of who has asked him why charges against Assange have not been dropped. And that's because people in the Senate, people in our Congress are perfectly okay with this. They do not follow the case closely. They don't have people on their staff who go to the proceedings or try to attend remotely. But there are parliamentarians in Europe, in European countries, who have taken an interest and know that based on human rights, that they need to follow what is happening because of the precedent that will be set if Assange is successfully brought to the US. And beyond that, because the United States is seeking to impose a domestic law on an Australian citizen. That is the fundamental point. There's a lot we can say about the corruption in this case. I spoke about the corruption during the live update I did yesterday. We talked about Ziggy Tredarson, the CIA, as was part of the proceedings today with the defense raising that matter. The FBI took Julian Assange's confidential materials. He had an archive. He had medical notes. There are things that are in the possession of the US government which would have been useful to putting together a case, and they don't have them. So they have been working at a disadvantage because the FBI seized those materials from the Ecuador authorities. We heard evidence about this during the extradition hearing in September 2020. And so I want you to think about what it means that the US government is doing this to an Australian citizen, saying that someone who isn't even an American must follow US secrecy laws and must be subject to this Espionage Act, which is being used in such a novel manner in the last 20, 25 years. The Justice Department has dusted off this 1917 law and said, this is how we are going to manage leaks. This is going to be the way that we put government employees or contractors who want to tell people the truth about what is happening in U.S. agencies. This is how we are going to deal with them and make an example out of them so that we can prevent the release of documents that'll embarrass us and shame us into behaving differently as a superpower, as a global empire. We don't want our dirty laundry hung out there for everyone to see. We don't want people to know how everything works internally and the way in which we go about strong arming people to get our way, how we pursue our wars, the brutality, the war crimes that happen with regularity during military occupations like the ones in Afghanistan and Iraq. We do not want people to know that, because to expose it would mean that then we have to defend it. And we don't want to defend it. It's very clear that the Biden administration does not want to defend it. That's not these people. They are not the part of the political class that stand tall, ready to defend their thuggish nature. No, that's what Trump does. That's what John Bolton does. That's what Dick Cheney and George W. Bush, it's what people like Colin Powell, who recently died, and Donald Rumsfeld, they had rationalized the way in which the U.S. engaged in foreign policy and projected and tried to show that they were strong. But Joe Biden's much different in the class of people that tend to come and go in our government. And Kamala Harris and Merrick Garland and Chuck Schumer and these people who rise to power and are given positions in leadership, Adam Schiff, and people in the Senate Intelligence Committee, someone like Dianne Feinstein, who's, it's amazing, is still alive and in the Senate. These people don't think they need to answer to anyone when it comes to concerns about what the U.S. security agencies are doing. They will decide what is corrupt, and they will decide the terms of accountability, and they will decide what is unjust. And since they have determined that it is within the bounds of what they want to go after Assange and bring him to the U.S. for trial, then they act totally ignorant of anything else that is said. They act ignorant of every detail that is put forward by human rights organizations or press freedom groups in relation to the corruption in this case. The due process violations. The prosecutor, James Lewis, wants everyone to think Niels Meltzer, the UN special rapporteur on torture, not the raconteur on torture, but the rapporteur on torture, James Lewis, has said is a kind of a kook. He treats him like a kook, like somebody who we should all just see as an outlier who isn't speaking eloquently and with great detail about what Assange has endured, the kind of psychological torment that he has had to suffer through arbitrary detention that's been recognized by the United Nations Working Group. And it's just a fact that with the United States, we're ready to recognize the United Nations whenever it suits U.S. foreign policy. They want Taiwan to, get some UN recognition because that'll get under the skin of China, which is, that's the great power competition that is likely going to be the doom of all of us if we aren't careful. But as far as Julian Assange goes and the assessments of anybody who has any ties or links to the United Nations, well, that's to be brushed aside as something that should be ignored. They selectively do that. And so this class of people with Merrick Garland at the head of it, because he's in the Justice Department, he's the one that has the authority to end this right now. And he can go to that National Security Division and say that this is not something that they want to be pursuing any longer. Because it just doesn't fit what the Justice Department does. I mean, they could say clearly, we are not going to pursue cases that endanger journalists. So what if they don't recognize that Julian Assange is a journalist? They should, but so what if they don't? They can at least recognize that no matter how they pursue this case, they are endangering journalism. But they won't. And up to this point, they haven't. And I really don't expect them to acknowledge any of these things that need to be recognized. We are waiting. We are in this game of punishment by process that we're just waiting for all of this to play out. The high court, maybe they rule against Julian Assange, maybe they don't. No matter what, there's an appeal that goes before the Supreme Court, the UK Supreme Court. The UK Supreme Court is then going to rule, and then maybe they rule against Assange, maybe they don't. But then it goes to the secretary, the foreign secretary, and we'll see if the foreign secretary signs off on it. The foreign secretary signs off on it, then it goes to the United States because he's going to be extradited. I don't know if the foreign secretary can still object to these decisions that come from the Supreme Court, or if they have to go by what the Supreme Court says. But in the past, Gary McKinnon had been stopped from extradition, had been saved from extradition by a foreign secretary. So anyways, we could get to this endpoint where we're waiting to find out if the final order is going to be signed off. And then Joe Biden might just decide that his administration doesn't have the appetite for what is going to take place if Assange is put on trial. It'll be a really extremely sad day for all of us to know that they spent the last 4 to 5 years doing this to Assange without any intention of ever putting on a trial and trying to bring him to quote unquote justice. And that it was all for the CIA's enjoyment and their sick pleasure to see what they could do to further destroy and ruin somebody who was given awards for the work that is criminalized and at issue in this case. The war log documents, the U.S. State Embassy cables, the collateral murder video, the Guantanamo files, a lot of this has all been featured in journalism from mainstream outlets, human rights reports. It's been part of a lot of legal cases. We've heard from Khalid al-Masri, who used a state embassy cable that helped him to win a small amount of justice through the European Court of Human Rights against Macedonia for being involved in the CIA's rendition and torture of him. And so this is truly where we are. This is what we are sitting in right now. This is what the Justice Department under Merrick Garland is allowing. This is what the Biden administration is allowing. And this is why we need to continue to cover and spread far and wide what is happening in this case. Not our speculation, not our cynicism about how this will go, but the facts, the things that are truly taking place. Share the quotes, share the things that are being said, the things that are the most incredible statements, the most repulsive statements that a prosecutor can make, whether it's stigmatizing mental health or saying things like, if he's in solitary confinement, then that would mean he wouldn't be able to talk to his attorneys. But since he can talk to his attorneys whenever he wants, it's not solitary confinement. Or they could yell through the steel doors or the walls of his cell and he would be able to talk. And so it's not solitary confinement because he'll be able to interact with prisoners who are in his wing, which is just absurd. It's absolutely absurd. So I thank you all for tuning in to this broadcast. And I'm glad to have all of your support for my work. If you're not a subscriber of The Dissenter, please go to thedissenter.org. If you're not a subscriber of this channel, please hit subscribe on the Shadowproof YouTube so you'll know when I go live in the future. When it's time to report on the High Court's decision, there will be another broadcast like this. Perhaps in the run-up to the High Court's decision, there will be further live broadcasts. You'll want to get the alerts, so be a subscriber of the YouTube channel. And then, like we said earlier, but if you're just joining us and missed it, if you would like further discussion with other people, there's a panel that I'm going to be doing with the Defending Rights in Dissent hosting at 3 p.m. You can find that floating around on Twitter. Unfortunately, I don't have a link handy. It's a webinar, and you can sign up. There's also a YouTube page. You'll be able to watch video of it on YouTube. And then receiver reporting. Look to the dissenter.org for a report on day 2 from Mohammed Almazy. And I think that about does it. I am not quite exhausted, but getting there. I have a few more things to do before I get to catch up on some sleep, though. So I'm going to go take care of those tasks, and I will be talking with all of you again soon. See you around.